Okay. Okay. Good morning, everybody.
Good morning.
Good morning, Mark.
It's good to see everybody on as we continue to continue this interesting first month of the year of 2022. With everything that's going on in the pandemic, as well as everything that's going on in the legislature. I don't know which one is crazier. So we're going to make an attempt at and perhaps both requires mask. I don't know why I said that. I just thought it'll bring some smiles to some people's faces. We can make that analogy later, but I'm trying to be very positive. As far as myself, I mean, I'm still involved with the legislature. So let's see what happens to us, or see how I look, by March, if I'm still sane. And then, we are in an election year, so it's going to be an interesting show in the legislature.
Oh yeah.
So I thought as we're going to discuss some important legislation and how it relates to us, and all of you who are faithfully in attendance to our for our hopes in reform in the correctional system. Thank you for coming and being part of this meeting. Martha Tournay will not be able to join us today. She's a little bit under the weather, but we have 4 of us who are here that'll be able to make the decisions we need to move forward. Kat, I'm going to be going off the form that you shared with us, and I appreciate all that time and effort and late nights and early mornings that you put together of all the related public safety bills, and for Carrie Ann and for Bob for your submittals as well. But the way you laid it out is really interesting for us, and I believe we can really move through this.
Yes, thank you. I got 16 pages.
Yeah. But I think some will be simple and others will be more complex, but I think it'll be able to move smoothly. And I believe when we open up testimony, those that are really at the heart of you who are here, we can expand, you can help us in the discussion process. Yeah. We're really looking at one, and before we start the meeting, I'll say this, and I'll reiterate it later. Is it or is it not our responsibility, or when it falls within the mandate of the commission? 2 is what the position will be. Yeah. And in your testimonies, perhaps you can relay it like this. Is it our kuleana? 2 is the position. And 3, there is an understanding that we all have to have as a director speak about each of these bills, that we will need to be open to the fact that we will support the intent of the bill, and we literally have no control of the amendments. Yeah. So once we submit a testimony, it's going to be on the intent of the bill. And hopefully you folks, as well as what we can do in terms of if questions are needed by the specific committees, that will drive the bill or not drive the bill. So that's the understanding on our role. Kat, probably not now. I'll call upon you later, or Carrie Ann. This is one of those no staff questions. I may need you to help us navigate. Normally, whoever signs the testimony is the one that does the explanation. So there are some issues in these bills that you presented that Ron is the best of the commission to testify, or Ted is the best, or Martha is the best. So we need to determine that as we move forward as well. So we got the best director in front of the best bill that we want to support. Okay. And or if we can, multiple directors, if that's allowable on the way that they're allowing.
Mark, you mean commissioners?
Commissioners, I'm sorry. Wrong hat. Let me switch. Okay. Commissioners, yeah. You know what I'm saying? Because there's a certain way you have to put your name in with the testimony in order to say something or be able for questionings for the committees. So I don't know, hope I didn't confuse you, but I know you folks understand because you're always going to these hearings. So with that being said,
Mark, I just want to clarify when you say supporting the intent, I think every bill has a basic concept behind it and the details in each bill. Well, most bills anyway. And I agree with what you're saying, but I just want to clarify. When you submit testimony saying you support the intent, that sends a certain message
Yeah.
to the legislators. And I think when we look at bills now, we can support a bill, but what we really at this meeting need to do is support the concepts behind the bills, because if the bill is amended, we cannot get together every time a bill is amended to review the amended bill. So, but we support the basic concepts, and whoever, I think we have to trust whichever commissioner is assigned to write testimony or provide testimony is able to make the appropriate adjustments without coming back to the full commission.
Yes.
Well taken. Concept versus intent.
Yeah.
Perhaps that's as we go through, that's the idea that we'll move with. Most testimonies I've seen from the state, Ted, they always talk about intent. So that's where I was coming from. So, but concept is just as good as well. So I'm good.
Yeah. Basically, when my observation is when people say we support the intent in formal testimony, they're saying, well, it's a good idea, but
Yeah.
yeah. And,
maybe that's why as a state worker I'm too familiar with that.
right.
Okay.
And Mark, I agree with Ted. We ought not to waffle. We could have a position and still be wrong, but I hate waffling. Waffling is Dante's Inferno talks about people who waffle. And you don't want to hear that lecture.
No, this is I'm a student on this one right now, so I'm game. I'm okay. Ron, any comments on that? That's good. That's a good discussion, Ted. If not, let's open up with anyone who wants to put forth something that on the legislative slate that it's close to your heart at this time. Just signal me with your hand or your digital hand.
Mark, well, I just want to make one point. If we're going to go off Kat's list, and by the way, I wasn't able to open Terry Ann's, but if we're going to go off Kat's list, there was one bill I noticed that's I don't believe is on Kat's list.
Yeah.
It's a HB 2169 relating to ID cards, and I'm sure there's a Senate companion because it's a PSD bill. It's an administration bill, and so I just want to add it to the discussion. Okay. Make sure it's added to the discussion.
That's fine. I wanted something for us to be guided by Kat, and yes. Then whatever else that somebody else knows of another bill, we can discuss it as we move forward. Thank you, Ted. Go ahead, Kat.
I just wanted to say, when I looked at the January 17th population report, 69.2% of all the people incarcerated by Hawaii are either in jail or they're parole or probation violators. And that's a huge population of people. So I think we need to be really mindful about pushing for not incarcerating people who are not criminalizing the poor, because so many people are in jail from the street. So it's really bad. And jumping to what Ted said, I've been in conversations with the department about the ID thing, and Tommy has been working diligently with the Department of Transportation. There's a MOA or something that has to happen. So I've been keeping in touch with him, but they're apparently moving forward. They did get money in 2016. They bought a machine that didn't work. So they're having some problems, but apparently they're going to shift it over to DOT to do the IDs.
Is that all, Kat?
Oh, I have plenty on bills, but yeah, no, that's fine for
Okay.
now.
Bob had his hand up.
Bob?
Yeah, I was on the Oversight Commission, I mean, the Reentry Commission back in 2018, I think it was, for a short time before it was taken over. And they'd been working on the ID for about 5 years at that point. So, you know, I mean, I couldn't understand why they couldn't get it done back then. We talked about that machine and all that stuff. And I mean, it's just really unbelievable that it has taken this long. It's just incomprehensible. But I wanted to make sure everybody got, I sent, I think, members of the commission, House Bill 2516 pertaining to OCCC, the new OCCC. And I just wanted to make sure everybody got it and that it's on the agenda for discussion this morning.
Got it.
Okay,
it.
thank you. Thank you. That's all.
Thank you, Bob.
Thank you, Mark.
And any other comments before we begin?
Mark?
Yes.
Mark, I want to note that Lisa forwarded an email to us from a Mr. Boyd Reddy, who is against the bill, no bail legislation. And I think we should note it as testimony.
I believe I saw that. Thank you. Yeah. Lisa, are you here?
Yes, I am.
Are we able to post that on the website?
I can post it. I'll have it posted.
Yeah, any of the test, okay. It'd be good, at least for me, when Ted says noted, that's the best we got right now, is to put it publicly on the website so that they know that there were opposition to some of the bills that we'll be discussing today, as well as 4, you know.
Mark,
Yeah, Mike.
I'm going to forward, I forwarded to the commissioners. I'm going to forward to Lisa for posting. Santa Clara County is going through the same piliquia that we're going through with the jail. A little bit smaller, but it is, it's amazing. It's a parallel potential disaster. So we need to be well aware of what Santa Clara does. And that usually is state of the art. And even they're tearing whatever hair they have left out. So I'm going to forward that to Lisa and maybe we could post it in the chat. Thank you.
Thank you. Thank you, Mike. Okay, Carrie Ann, did you want to have a statement?
Yes, so good morning, Chair Patterson, Commissioners, Carrie Ann Chiwota with the ACLU of Hawaii. I just want to clarify the agenda real quickly. I'm sorry, I came in a few minutes late. Are we now just giving some general comments and then you're going to take bill by bill?
We're at the public testimony on the agenda on any specific items. What I believe you're asking is, as we go bill by bill, the commissioners are going to be discussing. And if we require additional information, we may call upon some of you to add to our discussion.
Okay, well, I'll just make a general statement right now. Again, the last time we did an overview of the ACLU of Hawaii priority bills, legislation, and you now have them in front of you. We just would want to make the framework, set the framework for the conversation, and as you deliberate on which bills to support in terms of intent as well in concept. The commission, we believe, is tasked with the responsibility for a number of responsibilities, Kuleana, as you put it, Chair. And foremost, it is to conditions investigation, but also population management, getting the population to go below, definitely operational and ideally below design capacity, as well as on the tail end of people's sentence, reentry, rehabilitation opportunities, transforming the system. And so if you look at our bills that we're putting forth, all of them have the larger overarching goal of decarceration, reducing the number of our loved ones, family members, community members in our jails and prisons statewide, and ultimately even in Saguaro. If we take this approach of decreasing the population on the pretrial end through bail reform, also sort of towards the end, maybe not the end, but probation, technical violations, parole, technical violations, alternatives to incarceration. It makes up nearly about 20 to 25% of all admissions is technical violations, not for a new conviction of a crime, but because of technical violations. These strategies are proven effective. They are data-driven strategies and solutions to address overcrowding in all of our jails and prisons. And with respect to the moratorium, I did want to clarify the bill that's currently before you is paused. The ACLU's position is that we're actually asking for that bill to be strengthened and ultimately to be a moratorium. And when we get to, I guess, the bills that we've helped to introduce, we'll open to further questions. And we just want to say that there is, as Dr. MLK said, the fierce urgency of now. It's been 20 years, about 20 years since I've been going to the legislature amongst many of you, and we keep saying that we need to reduce the population overcrowding. Overcrowding is the symptom of the fact that we are not making changes in our laws, in our policies and practices. And so we need to get to the root of these issues, and the proposed bills will do that in a systemic systems way. So for every measure that's put forth, we ask that you look at the bigger systems approach, and that's what we're attempting to do with these proposed measures. And we hope we have your support. Thank you.
Thank you, Carrie Ann, for your comments. Anyone else at this time? Just looking for hands. Carolyn, did you raise your hand?
I put something in the chat about Boyd Reedy. So I'll look at that
Okay.
test too.
Thank you. Okay. Without any other visuals, let's see if I can do this. Hold on.
Mark,
Yes,
Mark,
Ted.
I'd like to make a comment. You're gonna put Mr. Reddy's make his email available to the public, but he also talks about an organized effort to influence us. And I just want to comment that this is a public meeting, it's publicly announced, and anybody who wants to join the meeting and provide comments and testimony is free to do so. And you know, if he doesn't like the so-called influences on us, he's certainly more than welcome to join and lend his opinions so we can hear them. I just want to comment, make that comment.
So noted, Ted. Thank you so much. I'm trying to, for the purpose of the commissioners. Hold on.
Mr. Reddy is running for office, just so you know.
Oh, I didn't.
Good.
Can you guys see the screen?
Yes.
I can see it, I can't read it,
Oh.
but I have the sheet in front of me.
Okay, hold on.
Small print.
I just want to make sure that we're on the same page so we can go down in a successful way. Does this help a little?
Uh-huh.
Yes.
Okay. We're dropping down to agenda 2. Thank you, everyone who had some testimony to give and things to share. I really appreciate you articulating those to us. No better way to start than to have a discussion with Commissioner Ron. Whenever we talk bill, we just associate bill with you, Ron. So I believe, you know, in these 2 items that are listed on the bill, and thank you, Kat, the way you broke it down for us, yeah, and understanding. In terms of our Kuleana, I believe this is important to us as bill is part of the act that created us. As we read this, Ron, you want to kind of look at this and then give us an initial conversation on position?
Yes, these bills, and Catherine can correct me, is similar to what was introduced last session of 1260, Senate Bill 1260, except I noticed now they're talking about video conferencing for what's that, pretrial determination as far as the ISC's bill study. So basically, again, in a nutshell, we're talking about nonviolent crimes overall. And you have the, of course, presumption a person charged is entitled to unconditional release unless proven otherwise. But in a nutshell, these kind of crimes include traffic violations, petty misdemeanors, and Class C felonies on all nonviolent that do away with cash bail. And certainly, the act also, when the bill also states that you must consider their financial conditions, that the charged, I wouldn't say defendant when they come to court, but defendant, not financial conditions. So I believe that, the commission was on board with this bill back when I testified, and when you folks told me to write testimony on Senate Bill 1260. And looking at it, it's looked like this year, has a good chance, hopefully. I'm hopeful that it will go through, because there's also a House bill. So there's a Senate bill and a House bill going through. And so I recommend that we support it, at least the concept.
And the House bill is being heard on Tuesday at 2:00 in House Judiciary.
This is the 1567.
Yes. HB, yep.
We supported this bill last year. Yeah. As a
Yes, and
commission.
Senate
And
Bill 1260, I think, Cap, is that right?
Yes.
And Ronald wrote the,
Yeah, we submitted testimony.
and I may still have that too as well, if we need to update it.
Yeah.
So if I just have one question, and looking at some of the things that Carrie Ann was saying, and just curious, for the line judge, should this pass by law, what is the tools that will give the judge, and how do we assure that the judge will actually, will there be a change in behavior of sentencing if this law was initiated?
Yeah, okay. Previously, without this law, the judge has total discretion on bail. Basically, whatever crime comes before the judge, and whether the judge imposes bail or other conditions, and it should certainly be the least restrictive, but that's broad. This bill will say, judge, for these nonviolent crimes, traffic violation, petty misdemeanor, Class C felonies, unless you find a danger to the community, public safety issue, danger, they should be released without cash bail on their own recognizance, actually. You talk about on promise, other jurisdictions call it differently. Here we call it OR, own recognizance. Other jurisdictions call it on promise to appear and things like that. But so what this does is tells the judge they are basically going to be released on own recognizance unless you find the public safety issues. Whereas without this, the judge can just impose cash bail. Certainly, judges should not, because they should have what they call the intake service center report, which makes a recommendation. And hopefully, to remind the judge of the statute, if it passes, the ISC report would also contain that, because this comes under the, or maybe not, because if I was sitting, I'd say, well, I don't need an ISC report. ISC people, you do a pretrial bail study on people that are not covered by the statute. So you get more time to focus on the other kind of crimes, which require, I would say, bail studies. Don't waste your time doing these, because this by statute say it basically you released on own recognizance. So the ISC would have more time to do other bail studies. And the judge will look at and be familiar with these traffic offenses, violations, petty misdemeanor, non-violence, and just say, well, prosecutor, any objection under the statute, I'm releasing the only recognizance. So that's
But that was good. That was good. You know, it's really want to pass something that has some effect and an ability to provide relief for the judges on their bench to pay attention to the more serious issues that are in front of them. And I think that's a good idea. Any further comments from you, Mike?
No, I'm good. I agree.
Ted? So this is the first bill that we're talking about, and I'm trying to get a flow of Kuleana, our position on it to support.
There are several other bail bills. SB 2778 and SB 2871.
Are they on this sheet that you made?
I don't know.
it's
No.
on Carrie Ann's ACLU sheet.
Okay.
They were putting stuff on in drips and drabs. I was going crazy.
Carrie Ann, I had a hard time pulling up the stuff that you sent because I had to request permission.
Yeah, I apologize. I'm still learning how to share Google Docs.
Okay.
So if I could just maybe add, I think something for the commission to consider again is that when you are supporting measures, again, in terms of concepts, and there may be more than one vehicle, for example, under the larger framework of bail reform, when you submit testimony, really diving deep, like how is it going to change in terms of process and more importantly, in terms of outcome? And I would just encourage the commission to think about outcome and impact. So for example, the bail bill that you just mentioned that's being introduced on the Senate and the House side, it is last year's bill resurrected. There's a few other things added to it, but there are many carved out exceptions.
Yeah.
Extreme. And so if I can just kind of point them out real quickly. So it says that the section shall not apply if the offense involves assault, terroristic threatening, sexual assault, abuse of a family or household member, violation of a TRO, violation of a order of protection, operating a vehicle under the influence of intoxicant, DUI, negligent homicide, if it involves a minor, unauthorized entry into a dwelling, or any other crime of violence, or one or more of the following applies. Defendant has a pattern of non-appearance in the last 24 months. Defendant has at least one prior conviction for a misdemeanor crime of violence or felony crime of violence within the last 8 years. The defendant was pending trial or sentencing at the time of arrest. Defendant was on probation, parole, or conditional release. The defendant is also concurrently charged with a violent petty misdemeanor, a violent misdemeanor. The defendant presents a risk of danger. So when you look at it, there are many exceptions. And I think that when you add it all together, this likely will effectuate some releases from our jails. But in terms of the other bill that the ACLU is proposing, the other bills, if you want to look at outcomes and have a more significant reduction without harming public safety while still maintaining public safety, the bills that we are putting forth are more in alignment, looking at non-financial conditions like federal system, like New Jersey, and they were able to still have people to show up in court at 90% rates by using things like reminders, text reminders, other methods of getting people to show up. Sometimes it's as simple as somebody not willfully not showing up, but they don't have transportation or their kid's sick, they can't get to court. So not, again, willful fleeing the jurisdiction. That's why in our bill, we're not using the terms like non-appearance. We're looking at if someone has the intent to flee, and that is a much different standard. There are not that many people from Hawaii who are trying to flee Hawaii from the island in terms of reality, practical situation there. And so in our also bills that you see forth, we're requiring that the burden is upon the government to prove, and it should rightfully be so. If you're taking away someone's liberty, removing them from their family, the community, they may lose their job, they may lose their access to housing, they may lose their place in a treatment slot. for a number have their children potentially taken away by CPS. And so that infringement upon liberty requires a significant due process, putting the burden upon the government. And it would require under our bill that the court would issue an order, but put it into writing as to reasons, the rationale, the justification for detaining someone. And of course, starting off with non-financial conditions, as is the case in the federal government. You'll also see in our bill that there is this provision specifically that if the court finds that there's no absolute means that we have to detain someone, that they do take a look at the person's income ability to set, quote, reasonable bail. And so there is a provision in here towards the end, and I'm just going to pull it up for you. That
What's that
essentially
bill number?
So it's SB 2778.
Yeah.
SB 2871. It's actually the same thing, but it had two numbers and HB 2017. But at the back of 2778, it does say here that it requires the court specifically to put on the record, the court shall exclude from consideration any income derived from public benefits, including supplemental Social Security disability insurance, TNNF, and any income below the federal poverty level. If the person has no income other than the public benefits, or if a member of a household having a household income below the federal poverty level, the court shall presume that the person is unable to pay any bail amount. So we're actually putting in specific guidance and criteria to guide the court in making that assessment, rather than just saying this general, make a determination what's reasonable. This is coming out of language from other jurisdictions, and I don't have it in front of me and I can send it to all of you, but there is a model code that recently came out making recommendations for pre-trial reforms, not only from the Uniform Model Code, but just this month, the US Commission on Civil Rights issued a report essentially saying the civil rights implication, the racial implications, the disparities because of our current pretrial system. And so you'll see some of the things that we are recommending are in alignment with recommendations coming out from model codes, other jurisdictions, and even the US Commission on Civil Rights.
Let me stop you right there, Carrie Ann. This is, can you see what you submitted to me or us?
I can. So those are the ones that I just mentioned, those three. I'm sorry, it's probably because, again, even when we're going through all of the bills, some of the things weren't on the list, or it was hard to find because these bills came out later.
Yeah.
Ron, when we look at what we just reviewed on Kat's list, and these are two additional bills that are added from the ACLU. When you read this and you look at it, will what you just mentioned to us change?
Yeah, well, generally speaking, first of all, so as a commission, when we started talking about our position on bills, are we saying, and it was good that Ted brought up, the concept, right, or the intent. So there's going to be bills that, certainly the concept is to reduce the pretrial jail population, but how you do it, we might disagree. And also, when we look at bills, we have to look at, okay, last year we supported whatever bill it was, 1260, and then this year, the legislature now brings it about again, which means that at least with the 1260, they're working towards something. So if we go out and put all this new stuff in a bill, it's just like starting all over again. My approach is a practical approach. Yes, we want the whole ball of wax, so to speak, but realistically, can we get it? And, I'm looking at something that you can work with to start with to get some data and then expand therefrom, not change it overnight. And what I'm saying is we're starting with something that we've already started last year. And now, the ledge looked at it. And yes, I think we all agree with the concept, but how we go about in getting the bill passed is another issue. So yes, all these things that Carrie Ann brought up, it's great. Yes, if the ledge would buy it. I say that the judges have, all these exemption stuff, anyway, it's covered by, the judge. And most of the things that they read in the exemption are crimes of violence, except the no-shows and if you're convicted of certain other express crimes. So, but I'm saying is, look, are we going to go back to the drawing board again? As you know, legislators saying, well, you guys can't agree, we'll just put it on the side. I look at these bills, let's get something passed as a starter. And so we can address all the naysayers about, look, that won't work. In the next session, we can refine it with some already data that we have. So that's my positions.
Mark,
Yes, Mike.
two things that come to mind, because I'm, I was chief judge of family court. I was constantly in legislature and I actually enjoyed it. I guess I'm a little crazy, but we need to be aware that the prosecutor and public defender and the private criminal defense bar need to be folded in ahead of time, not later, because they're going to raise it every single time. And in the old days, when we had Keith Kaneshiro there, unless he agreed, nothing happened. I don't think we're in that environment anymore. I hope not. And the second thing is, unless we give judges specific fact finding, I don't know if Ron agrees with it or not, they got to do their job and use discretion. Because right now, as I understand it, they're just approving cash bail. And I'm very unhappy with that. That's a training issue. And Ron, do you have any, and feel free to disagree. Do you have any input?
Yeah, I agree. Judges are human beings, right? And hopefully, even though we say judges have judicial independence, like, I've felt sometimes while sitting on the bench, I don't know about you, Mike, where I tell my family when I'm kind of schizophrenic, where my decisions, I disagree, but I got to follow the Constitution and the law. Even personally, I may disagree my own decision. The law is the law, the Constitution, as I see it, and interpreted by the Supreme Court. So yes, I think the more, but I don't like like this mandatory sentencing, because it tells the judge what to do basically. But basically, because if you want something black and white, you're not going to get it. You might as well have a computer for a judge. So I agree. Judges should use their discretion. And every case is different, except maybe some similarities. But these statutes, which give the judges guidelines, say, okay, this is the guidelines. OR for nonviolent, and these are the categories. And I agree. Yes, broad categories as far as boundaries on the judges, but the judges should have limitations as far as politically. I'm looking at it different, because I too was chief judge in every legislative sessions. I didn't like legislative sessions because certainly I was a judge and not a politician, and you have to go up and provide testimony, as Fred knows, right? And sometimes politics and judging conflicts, right? Because the legislation, that's not the intent of the law that we passed. Okay, well, then they change it. There's next session, there's a bill to limit whatever the judge's discretion or give guidance to the judges. So I say just that, yes, we'd like to be specific as much as questions to give the judges parameters, because some judges, like I said, they're human beings, and they may be affected by public pressure or whatever it is. But yet, you got to give the judges discretion, and guidance. And I agree with Judge Town that basically it comes down to sometimes education, of the judge, educating the judge why these things are happening, and it's not just you get everything in the law, black and white. That too is bad, because it does not give the judges too much discretion, which you should give the judge. But that's my 2 cents.
Ron, just to digress for a second, we used to give mandatory minimums required by law, right, Ron? Remember that?
Oh yeah,
and then they'd say, and the judges balked at that because we wanted to use discretion. And then the legislature they were a little bit new about that. They said, well, if you're going to do that, you're going to make findings. I had no problem making findings to take away mandatory minimums and allow people who behave correctly to not have to serve this mandatory minimum. So that's the flip side. What bothers me is when they grant cash bail, and I can't see any reason. I think they should almost make findings as to why not, you know. But anyway, that's just my manao based on my time as a judge.
Yeah.
Quick comment on what you said Ron and Ted, maybe you can chime in. Is there a potential testimony that fits all the bills?
Like I said, you know, at the outset, Ted, you know, the concept, you know, we all agree on the concept,
Yeah.
right? Reduce the pretrial jail population, but how we're going to do it, you know, exemptions and things like that, you know, I think we agree that on the concept, reduce pretrial, you know, jail population. I think we also agree that non-violent crimes, right, should be covered under OR, no cash bail. But there seems to be now, okay, the ledges or whoever introducing the bills is having these exemptions for certain crimes, right? As like Carrie Ann read out. And I suppose that's where the discussion is. You know, what kind of crimes should be exempt under under no cash bail. But keep in mind, also, we started with 1260. The original 1260 has, you know, basically never had the, you know, we started way up the felonies above class Cs too. And then at the end of the session, at least people will go down to class C felonies included. Previously to that, I don't think any, well, I don't think there were unanimous agreement on whether felonies should be included. But, you know, so all I'm saying is, you know, let's get something that we think realistically can pass. And I think our out as the commission is basically we can say we agree with concepts or, you know, and we can just state where we might want some amendments.
Mark,
Yes, Ted.
Mark, we're on the first two bills of a 16-page.
No, I know, I'm trying to bring some closure to this. Go ahead, Ted.
I had a chance to take a look at one of the bills that Carrie Ann noted. Excuse me, I got a phone call coming in. I have to tell them to remind me.
Hopefully,
Can you hear me?
Yes, go ahead, Ted.
Okay, sorry. But anyway, I had a chance to look at House Bill 2017, I believe, and it's much more detailed. It's a lengthy bill. It's 9 pages. It puts a lot of guardrails on the process. And what I suggest is since we support the concept of bail reform, we took a position on a more generalized bill last year. We empower Ron to take a look at the additional bills and advise us as to and take a position on those bills as he sees fit based on his experience as a judge. Because some of these things in 2017, I wouldn't be able to comment on. For example, it places a time limit 40 hours after that there needs to be a hearing within 40 hours. I don't know how that's going to work. It talks about burden of proof. I don't know how that's going to work. I don't have enough information to take a position on those things, but I think people like Ron and Mike might.
This bail portion of the bills that we're going over, ladies and gentlemen, is really to teach us how this conversation is going to continue with the other bills, and it's really crucial. And bail has always been an important discussion point for the commission in terms of a reduction of population. So you know, what we really looking at having this meeting, and correct me, commissioners, if you disagree, is really to get a feel of how the commissioners feel, and so the public knows that we're gonna go one way, but we won't be able to discuss what we're gonna write about it. Yeah, because we're gonna leave it up to Ron to write a lot of the things as he sees on the bills, but we wanna know that as a commission, we wanna go with this route to support this bill. Reform measures. Trying to figure out. I get the sense of feeling we want to move in terms of, because they all address with bill reform. And then there's the sense of strategy to assure that at least the main one gets through. Yeah. Because if we support all of it, we might confuse the situation and then nothing passes. I'm not the politician, and so I'm trying to figure out the strategy that's the best suited for us to decide this stuff. We want to say that we want to support bill reform, but the real action is the testimony that we put in, and when we sit in front of and answer the question, should we be called to the plate? Yeah. And so because we've had this discussion, we have an idea on how we may comment on it based on our experience on the subject. Yeah. Did I just confuse everybody? I want to move forward. And Lisa, I want to stay within what our abilities are on the sunshine laws and everything like that. You know what I'm saying? To make sure that we're doing it right. If we're going to say something at the legislature, we want to make sure that the public knew we were going to say it. Yeah. And so, any comments on this process right now? Because we have a long way to go.
It might be better than if you just try and skim through it as much as possible and try and at the end, you guys can discuss amongst yourselves as to what testimony is going to, you don't have to strategize in public, but
so
as you said, you want to indicate to the public what ideas you're pushing at the ledge. I mean, there's so many bills. Like Ted said, there's 16 pages of bills.
So as the sections that we are discussing, let's just look at bail. Yeah, bail falls under our responsibility, our kuleana. Yeah, the way the bills are written, there's hardly, without looking at the entire bill, but just the description of the bill, there is that responsibility and a potential for testimony and support from the commission. Can we agree to all of that on the bills that we just reviewed, commissioners? That's the concept.
I agree.
Yeah. So with that being said, it's just a matter of how the testimonies will look. Yeah. For or whether or not we're gonna submit the testimony. Now, is there any issues around that? I mean, we're not committed to testimony on each particular bill, but we are committing, should we be called to speak about it.
Yep. Mark, what's going to be most effective if we prioritize where we are in strong support versus support. Support's sort of watered down, and anything else, I don't know if they're going to pay attention to. But I'm so not a politician. Thank you.
Okay. So
It might be easier if you guys just go through the 16 pages and maybe leave for the next meeting specific bills that you want to push or you want the commission to support. I mean, as Judge Town said, just general support is.
yeah, well, the whole point is so that we can submit our testimonies or be able to confront. Should a committee call commissioners to the table, we want to be able to have had these discussions so that we can guide a discussion with the committees. We are subject to be called upon. Yeah, and the last thing we want to say is that we've never discussed this in a public setting. or specific questions will come to us, we will say that was never discussed in a public setting. Yeah. So I agree with that. Right now, we're favorable on a lot of these things. It's just a matter of which we're going to implement our support. Okay. So with that being said,
Well,
as long-
I like Mike's framework, strong support or support. So bail reform has been an issue we've been talking about for more than a year. We've already taken a public position. I think bail reform bills are strong support. And given that, we can have Ron take a look at some of the other bills and make some judgments on his own, whether it fits the framework of our general support of the concept of bail reform.
Okay. Ron, you okay with that?
Yeah, I am.
Okay. All right, we get, we're agreeable on the bail portion as list, so presented by on Kat's report or listing, as well as Carrie Ann. So thank you guys. Let's move on to some of the bills that are within the Department of Public Safety at this time. I'm looking at that 1875, so I'm confused.
It's a short form. There's nothing there.
Yeah, okay.
Placeholder.
2452.
I really, this doesn't reflect any personal position, but I really don't see the management audit as fitting within our Kuleana.
Yeah.
Do you have the extent of the bill in front of you, or you just looked it up yourself? Appropriation management audit.
No, but given that I see the first introducer, the first signee, Senator Favela, my guess is that it probably goes to issues like staffing shortages and response to COVID.
Okay. Okay. Ted is recommending not part of our Kuleana. Ron or Mike, anything?
I agree.
I agree.
Okay. Let's move on and look at the next one. Sorry, I'm taking notes right now. (1737) corporate prisons.
This bill is trying to get the original intent of the Oversight Commission in statute for out-of-state contracts. So that would be, people should be released at their minimum term.
I'm sorry, is this a budget issue, Ted?
No,
I don't
it's
think
a
this is a budget issue.
policy issue, I think.
Excuse me. I think what I skimmed over this bill, and I think what it's saying is that it expresses legislature's position that inmates should be brought home at least by the time the minimum terms expire, and if they don't, the per diem rate that we pay to the contractor will be reduced. This will
Yes.
create an incentive to get inmates released on the minimum term. but at or before the minimum terms, I should say. And at first, I wasn't sure as to whether how this fits in our Kuleana, but now I see that this really becomes a population management issue, a
Yeah.
capacity issue,
Yes.
and I believe this really becomes a reentry issue also, which is also part of our Kuleana.
And with that being said, Ted, and you having, I'm leaning towards you and Martha having the experience in this particular bill. Is this something we want to support?
I would support it.
Ted and Ron and Mike, you have any questions on this for Ted?
Well, I spent 5 days up there. We did 40 parole hearings, and I don't even think we should be there, number one. But number two, we've got the right people weighing in here. I'd like to know a little bit more why they're doing this. The problem is, who do we send up there? Do we send the easy ones up there that they make money off our backs, or they send the hard ones? And we should mute unless Mark asks a question. So I generally, if I understand the reasoning, I like it.
I have a question for Mike.
Yep.
Mike, in your this bill specifically addresses minimum terms. In your experience, in your time with the parole board, what was your observation as to whether inmates were coming back in time so they could be released under minimum terms or not? Because to me, that's the reentry issue.
Well, I agree. I don't know that answer. That's a fair question, Ted. And that's why I want to know why people are, A, we shouldn't be there. B, they should get back sooner than later. And you may be right. It may be reduce. It's the kind of people up there. So I can't answer your question. I don't know.
Yeah, I think it's a good question to ask, because as I recall, the reentry law talks about the reentry starts at intake, and reentry really is a process. And if inmates aren't being brought back from the mainland on time, their reentry is not going to be done on a timely basis.
And Ted, I think the judges should set the minimums, not the parole board. I think that's a giant flaw in the law, in which we'll talk about it. It's crazy to push that onto the parole board. When I was on there, minimums used a lot of our time, and I didn't think we were very good at it, to be honest.
Yeah, I think like Judge Town said, if the court sets the minimum, or determinate sentencing, is this going to now bring a whole reform on our sentencing scheme? Basically, Hawaii is an indeterminate sentence, right? State.
Basically, yes.
Which leaves the parole board to set the minimum.
I think, Ron, we're the only state in the union where the parole board sets the minimum.
Oh.
And we're the card that flew out of the deck.
Yeah, well, I don't know if, frankly, if I was sitting as a sentencing judge, that judges in general have all the information to set minimum, and if so, we're going to have to, the judges hopefully would take more time to get all the information that would allow the judge to say, okay, this case would be minimum X months or years, although the other case basically was the same charge and offense, different because different circumstances. So, basically with the judge would need more information, but finally, I'm open anyway.
Yep, Ron, the argument is that once they're program compliant, they're eligible for parole unless they have some very difficult misconduct, and there's misconducts and there's misconducts. So I don't see the need for minimums, but that's a discussion people feel really strongly about. And So I think you're right.
Let's see if we can support Ted's supporting of the bill, and then so that he can be able to write the, or him and Martha discussing and write the testimony in support. That's what I'm hearing right now without going into more intimate details. Are we okay with that, Ted? The way I said that?
Yeah.
Mike,
I'm
we
okay.
agree?
Yeah, and I'll talk to Martha about this.
Okay. Ron and Mike, we okay with that?
Yep.
I am.
Yep.
All right, that was House Bill 1737, Arculiana, basically in its efforts to for population control and reentry issues as mandated by the act that formed the commission. Let's move on real quick. Correctional industries.
Nah,
I think it's I don't know where that's coming from. I don't see this much as our Juliana.
no. Can I say something? This is Kat.
Real quick, because we may be moving on quicker than we
Okay,
want.
no, I just wanted to say that related to the last bill is the fix for the Act 179, which is SB 2305 and HB 1739. That's the one that changes from that people need to be released at their minimum rather than their maximum term.
Okay,
So it's related to the
Yes.
prior bill.
if I'm gonna make a final comment on this in terms of Kuleana, Hawaii Correctional Industry, and Ted, you know, you were there when it was created. Really a program to help work ethic, skill building and training for offender population. And, you know, when fully mobilized, very effective. At one time, they were printing all the state documents out of their print shop. But mainland COVID, I don't believe they're capable of doing what the law says that they're doing, what this measure is asking. Yeah. So
Mark,
yes.
I just want to note at this point, it dawned on me just now, after I made my comments, that I do have a conflict of interest on these bills because I am on retainer to a company that provides services to correctional industries.
Okay, I'll keep you out of this conversation, Ted.
Okay.
Okay. Ron or Mike, you have any comments from your perspective?
Mike, I don't have any comment.
What's going through my head right now is we're talking about how we want to support bills. Do we want to say anything to say maybe we not support the bill? No.
In fact, unless I think if we have a strong position, we should maybe just not submit testimony if we don't necessarily want to support it, unless we have a strong opposition.
Okay. At this point, I'm gonna suggest we just move on from the correctional industry bill. Put it on hold. Education and training. These are reentry. This is a House Bill 1543 is a reentry program, which we can be supportive of. Requires the Department of Public Safety in collaboration with the Department of Human Services develop and establish a program to train incarcerated nonviolent individuals in the areas of social work. Any comments from? I do know in my time with public safety that there has been a group of women coming out, going to the university or Chaminade and getting their social work degrees and being hired by in this by state systems as peer specialists or social workers. There's a part of me that wants to lean this way because that is an avenue for them to give back to the systems, child welfare, foster care, mental health, based on their learning experiences and the education that they received from the universities. A lot of their education started within the correctional system. If the School of Social Work or is willing to invest into the facilities themselves, this can be a positive reentry element, as what I see at this particular point in time. Ted?
Mark, I want to comment. First of all, there are 4 bills in this packet.
Okay.
One of them, 2214, that's the 3rd bill on the list, is a little different. The other 3 bills under this
Education.
heading of education and training really relates to training inmates to work with other inmates, to become certified or even degreed to work with other inmates. And I support the concept. I think in the area of substance abuse or substance abuse treatment, we had learned that sometimes former users were very effective. And I remember when I hired the first ex-inmate to be on the staff to work in the substance abuse program. We eventually hired several of them, but they were quite effective. So I support the concept behind these 3 bills. That's 1543, 2375, and 2773. And I noticed the next one, educating women as peer tutors, it goes in the same direction.
I think we can be supportive of all the educational measures that we're looking at this particular point in time. Did you have a particular comment on the one that you pointed out?
2214.
Yes.
I recall what I think that's a good bill. What that bill does is it says that the PSD should hire social workers to help inmates with issues like mental illness and housing issues, to steer them away from the system. I don't have the bill itself in front of me, but my only question on the bill was whether it's something that should be placed in PSD or somewhere else.
I see. I believe that let's answer the first question. When we look at these educational opportunities and the programs they hope to develop for within the system, we can agree it falls under our reentry Kuleana. Mike?
Yes.
Ron?
Yep.
Okay. So this is one of the ones we can support the intent. Yeah. Oh, sorry.
Yes.
I would say I would not say the word intent anymore. That we can support, strongly support in some aspects. But I don't think we need to speak any more to this. But particularly from everything under education and training as listed on the current document that I'm sharing, we'll go ahead and say that we'll be in support, and we'll work with Martha, who's this is more along her lines to how the testimony will be presented. Are we okay?
Okay.
Okay. Thank you.
Okay. Mark, on 2214, I pulled the bill up, and what it does is it says the Department of Public Safety shall establish a 5-year pilot program to require social workers to accompany public safety officials to respond to reports of disorderly conduct and other offenses as deemed necessary, where when it is indicated that persons may suffer from substance addiction, mental illness, homelessness, or other catastrophic afflictions. So I think it's something that we've been talking about, the need to steer a lot of people, a lot of defendants away from the justice system and into services. And my concern is I don't think this is a public safety responsibility unless because they have very limited jurisdiction in terms of law enforcement, which would be the sheriffs. But I think it's something that we've been talking about for a long time. The concept anyway.
Do we continue to group it with the rest of the measures in this section? For Martha's discretion?
Well, it's more a jail diversion type bill, I think. So there'll be a social worker accompanying the law enforcement officer, and if it's a homeless person, we try to hook that person up to housing rather than sent to a CCC.
Okay. Okay, we'll leave it as it is. Is that okay?
I think we should support the concept.
Yeah.
Yeah.
That's what I'm thinking.
Okay.
Yep. So a lot of these bills are doubled, yeah, because you're presenting the Senate bill and the House bill at the same time. That's why a lot of lengthy document, right, Kat?
Yes.
Okay.
Yeah, so you can skip over a lot. There's just things that are really important to this group, this commission.
Good question. Okay.
I hope you support the fix to Act 179.
Yeah, it's still on the list though, right?
Yeah.
Yeah.
Yeah. I'm just looking at this Family Resource Center and everything that you presented here right now.
So the first two are the governor's bills.
Is there a reason why it's only at Guayaba?
Well, we wanted to do it broadly, but we decided after meeting with the department and with the former warden of Guayaba that it would be good to do a pilot program to show that it could work. So we've been working with Blueprint for Change and a whole group of family reunification people. So there are, I think the better bills are the next two.
Understanding that Guayaba is the reentry point or beginning of the journey of reentry, and I'm assuming that Family Resource Center is a continuing effort on the department for family reunification.
Yes, and Guayaba actually had a building that they could retrofit, and that's why it was deemed to start there, because they were more amenable to doing it, and we figured we could maybe skill up some people who are inside who are good at construction or whatever needs to be done to retrofit that building.
So we're asking for more of human services involvement and engagement in this effort with the family component rather than the individual.
Yes.
Yeah. We have the understanding that whenever we send someone to prison or into the correctional system, the family is always affected as well.
Yes.
So as we work on the offender and I hate to use the word, but I'll just throw it out there, that, the issues, whether it be education, substance abuse, mental health, there's also a parallel journey for the family. And what I hear you saying is that once they're identified, human service would pick that up.
Well, it would be, the whole resource center would be run by social services.
Oh, I see.
And Blueprint for Change would actually work on that piece of it.
Mark, I think this really fits. I think there's ample evidence out there throughout the country that shows that family reunification is a critical part of successful reentry.
Yep.
And family reunification cannot start after the inmate leaves prison.
And so the company bill is for the position, will be within the Department of Human Service.
I noticed
Right.
Senate Bill 3111 and House Bill 2143 are Kochi by request and Saki by request, which tells me that
Oh, they're the
this
governor's
governor's bills. Yes.
Yeah, so the first two are the ones that actually the Family Resource Working Group has been working on.
There's no doubt that, however it may be written or not even articulated, but intent that this is important for reentry.
Yeah.
For everything that we do, population control in terms of they have to go somewhere. So yes, I believe our Kuleana is in this this Family Visitation and Resource Center. I believe that we can support this. I'll strongly support it. Mike or Ron, any comments?
No, I agree. We support.
I agree.
Okay, let's move forward. Native Hawaiian programs.
Mark,
Yes,
correct me if I'm wrong. We have a new executive director of the Native Hawaiian Legal Corporation. Is that right, Mark?
yes,
Is that Makalika Naholova'a?
yes.
Be good to invite her to one of these because I think this is given what's going on. I think it's important. I think both you and Bob are on the boards, right?
Yes, we can make that happen.
I don't know her.
We can make that happen, Mike.
Thank
real-
you.
Real quick, Ted.
Yes.
Is this like an administrator they're asking for to create a cultural programming in the department?
I don't know exactly what they're asking for, but there's an appropriation, so it'll probably provide staff for PSD for this. I think this is ground that we covered back years ago when I was still there, and I think it's the Native Hawaiian rehabilitation. There was a time when I was kind of embarrassed because we had a better Hawaiian cultural program in Arizona than locally, and I'm hoping that that we've kind of caught up here in Hawaii, but there's still a lot more that can be done. The only thing I would want to see is that programs be continuous, that so that be programs not only at Halawa, but they will articulate with programs at Waiawa and Kulani and into the community thereafter. I think some of the concepts that are attendant to this Native Hawaiian rehabilitation programs are applicable to most inmates, but particularly to the Native Hawaiians. But there's a lot more, of course, to the Native Hawaiian rehabilitation programs. It's a cultural identity. It's a connection to the Aina, connection to your communities, etc. So I would support these bills.
Along with Ted, I believe there is no question on our Kuleana over this.
Well, Mark, you did a lot when you were at the women's facility.
Yes.
Yeah, I'm trying to frame a response. There is no doubt outstanding individual cultural programs that come in and out of the facilities, as well as Arizona. What this presents to us is an administrator within the Department of Public Safety's program division that will solely look at putting the programs together to create a journey of Indigenous care. Yeah, we want to be able to create a program that goes throughout the facilities, that whenever they leave one and go to another, as they progress through, that they're being offered and that they take them to another level, another step. When we talk about Indigenous model, we're not there yet. We have great individual cultural programs that are being conducted, but we need to have an administrative level organizing a system of care within this Indigenous model. And I'm very supportive of this. It would be a next step. Yeah. Some of these cultural programs are more easy for some of most of our Native Hawaiians can walk into a cultural program and immediately relate to the practitioners who have come in to help them. And that begins a journey for who they are, where they fit into the society that they are coming from. So
Sounds like you got the testimony written, Mark.
did I just volunteer for that, Ted?
Yeah.
Sounds like it to me.
I'm sorry. It's been work.
We're not.
Okay,
Mark,
Mike and Ron, any suggestions so we can move?
yeah, one of the challenges I had as a parole commissioner was trying to understand the Polynesian Native Hawaiian inmates, what they saw as their culture. And you're exactly right. And they need these programs. Many of them had beautiful Hawaiian middle names, and either they didn't want to share it or they didn't know. And it usually came from grandma or grandpa, or came down. And and I think this is so needed. And I've discussed this off and on again with Kiha Pimentel, with other people. And so I really support what's going on here. I don't know how to roll it out. When I was in Arizona, they had a very strong cultural, they had all the accoutrements, drums and everything. It was amazing. So thank you.
Okay,
Yeah,
I have a sense that we're going to go ahead and move and support this particular measures, and I'll volunteer for the testimony.
Yay.
Pat down in searches for women. I just want to share real quick, yeah, just from what you shared here. Two things within public safety, and this is open for discussion, so I'm just going to throw this out. Within public safety, we have what we call gender-specific posting, yeah, which requires the facilities to have a female present at all times. Okay, so that's one. Those are all in negotiations with the union and all identified in selection, so that women officers are known that they have to, depending on seniority, they have to pick those positions. Two is a federal law called the Prison Rape Elimination Act, yeah, passed by the Congress back in 2003 or 4. Three that mandates the states to follow particular standards in order to assure that sexual assaults, sexual harassment, and privacies and et cetera, everything that you see here is being done. Yeah. And there's strict standards to this. You can actually, for those of you listening, go on the website, Prison Rape Elimination Act Resource Center, PREA Resource Center, the Moss Group. These are the leaders in PREA, and you can learn about a lot of what they're asking for is already being done. Yeah, the state, all the facilities, including myself right now, we have to undergo annual, every 2 years audits. Someone from the mainland will come down and assure that we are doing the PREA standards and that the women and the men are safe in the environments that we've placed them in. And a lot of what you see here, we have to have records for. Yeah. So all I'm trying to say is a lot of this is already given to us under federal law. An individual facility has to pass the audit. Yeah. And you have to be what they call PREA certified. If the state fails to have all its correctional facilities, including the youth, certified, they will lose federal funding from the COJ. So that's just some inside information. Ted, you want to add to that? You might not be there.
No, not really. It's kind of a no-brainer that something like this should be in the policy anyway, and it should be drilled into all the officers at training. So the only thing is, I don't know whether it fits within our Kuleana or not.
Yeah. And I just wanted to share that with everybody so you understand when I move on that there are should there be complaints or accusations, the system is designed to respond immediately. Yeah. And there will always be an audit. For example, all sexual assaults is a record that every facility has to maintain on an annual basis. Yeah. Camera systems, what they're able to see, what they're not see, visualize areas. Everything that you see here, there's an accountability for it. So I'm just saying it's already in place. It may be shadowy in terms of our responsibility to it, but I just want to share that it doesn't mean that we're not concerned about it, but there are things in play. So I'm going to move on to Ron and Mike. You have any questions to that?
Yeah, I don't think we should micromanage public safety unless we have to, and let managers manage. But and it's hard to be against this. Who isn't?
Right.
Yeah,
That's why
I agree.
I just wanted to share the policy aspect of it that's already in play. Thank you. Let's take 2269 by itself real quick. Is it our Kuleana? Prohibits the establishment of private correctional facilities within the state, allows the governor to enter into contract with a private entity to construct correctional facilities on public or private land. You could probably make arguments. I want to say no.
No. By no, you mean?
Kuleana, responsibility. Initial thought. Mike?
Well, I mean, my gut says we don't need our people in another. We should take care of our own problem here. I don't know why we're in Arizona, and I've heard both sides. So you would say we should vote against this, or you say don't have prisons in other states. What are you saying, Mark?
How much effort do we want to put in as a commission to either support it or not support it?
No,
Yeah.
Mark, what this bill says is no private prisons in Hawaii.
Right.
And it's a privatization issue. And
Right.
to be honest with
that,
you,
sorry.
yeah, to be honest with you, I don't see how this bill makes it out of the legislature if HGA and UPW are watching.
The governor is negotiating with private corporate prisons, though. to build
This goes to the operation, but it allows for the governor to contract to build.
Is
Well,
this
I'm
the,
sorry, I
is this the,
misspoke.
pe-
I don't see how this, I think that the unions will probably just,
No, I
Jump on this
understand
one.
that. What I'm trying to say is as a commission, do we want to submit testimony? You know,
is this
Because-
the P3 thing? Bob
no,
Murphy, do you have any input? No, it's not.
no, this
Yeah,
isn't that.
It is a P3.
Well,
No.
I think it would allow the governor to sign a contract tomorrow with Core Civic to build a new jail, as long as the jail wasn't operated by
Core Civic.
by private people.
Yeah.
So this is exactly the opposite of 2516, as I see it. Am I right, Kat?
Well, it basically puts a ban on private correctional facilities entering Hawaii, which I think is a good idea, since, their justice should not be an economic issue. So, yeah,
But it says allows the governor to enter into a contract with a private entity to construct correctional facilities on public lands
or
or
private
private
land.
lands for the benefit of the state, as long as they're operated by the Department of Public Safety. So it means the governor could contract with Core Civic to build a jail right now, and that's the exact opposite of 2516.
Right.
I disagree. I think the governor has to be able. I don't think there's any major construction projects in the state of Hawaii that is not done by a private entity. I think this has to be there. You build a school, you contract with a private contractor to build it. The state doesn't go out and build it itself. The meat of this bill, to me, as I read it, is that we don't want a private facility. We don't want Core Civic operating in Hawaii. And I think that's a privatization issue.
It is.
Okay, I think Ted makes a point there that I was missing.
Well, I don't think we should take a position, Mark.
Mike, Ted,
I don't think we should take a position.
okay,
I agree.
okay. 2516, planning the proposed OCCC. We've already had a lengthy discussions the past several months on this, and Bob, thank you for your input. Positive development of a new jail to replace. We had a discussion in the last meeting, pause versus moratorium. Yeah, and I believe we took a stance on understanding the need for a replacement for OCCC due to the age of the facilities. Now, you guys correct me if I'm wrong. This is where we particularly are standing. I don't think we will. Right now, I know we're leaning to the support of this as written. And I don't know if we want or we need further discussion. As said, Mike, you want to start the conversation?
Well, I sent a memo to everybody about moratorium versus pause. I think there are bills in other states have a 20-year moratorium, a 5-year moratorium. I'm hearing through back channels that 3 might be acceptable to the legislature. So I don't know. I don't want a new jail until I understand who's going to be there and what it's going to look like. Is it going to be a campus or is it going to be another silo? I don't want a silo. So, and I think the wording's important, pause versus moratorium. Moratorium's got some spine to it, got some edges to it, where pause sounds kind of fuzzy. Thanks.
Ron?
I agree with Mike. Basically, pause is a word instead of moratorium. Basically, we do not want to stop, right, the construction. All we want is reasonable input by the community.
I want to stop construction.
Mark,
Go ahead, Ted.
I just want to further the discussion on this bill. There are two things in this bill. Number one is it prohibits the construction of any correctional facility in Hawaii using a PPP. And the second thing is it creates I think it's a council. So I think would be sort of similar to the community advisory group that we asked at PSD to form.
Right.
Except that this council would be under our commission, and there'd be an appropriation for that to cover the expenses. So there are really two parts to this bill.
Okay.
My position is, number one, I do not support the notion of prohibiting the use of PPPs, because I think PPPs can be a viable funding option if eventually we're going to need to build something. I think the state will need the flexibility to find the best funding mechanism. And PPPs are viable. It may not have worked in some jurisdictions as regards the construction of prisons,
Many.
but it doesn't mean that the whole concept is no good. The second thing is on the council. The question for us is placing the council within our commission the appropriate placement. So that's where I am.
I would like to work on the concept of putting staff in the commission.
Yeah.
Rather than,
Well,
you're
Mark, I
gonna,
think everybody agrees with the concept, but we need
Yeah.
some people to take some action.
yeah, I know, but they want to add some more components to us, but it's
Yeah, you tell me about it. Yeah,
an appropriation. But
another
Okay.
phantom position. No?
Yeah.
But anyway, it's been going on 2 months since we sent the names up.
Yep.
okay, so Bob, that's pretty much in the bill that you sent to us, right?
What's that, Mark?
What Ted is talking about?
I'm not sure how to answer that. The bill doesn't stop as I intended it. It doesn't stop. It's focused on OCCC and building a new jail and using a public-private partnership for the new jail.
Okay.
And it doesn't prohibit that forever. It just says until the bill is repealed, they can't work on planning that. They need to go back and look at how do we conceive of a jail that will be smaller and less expensive by presenting off ramps along the way, so that we don't trap the people in the jail that we don't want there. And to do that and make those kind of recommendations, you really need to engage the community. So it creates the community a group to be, as we put it, as you guys put it, a full partner in the planning process going forward. So what it attempts to do is basically put a halt on further work on a P3 for the new jail, but allows planning on a new jail as long as it's not focused on the P3, but on reducing the number of people who are going to come in the jail and improving the criminal justice system as part of the new jail, because it embraces the concept that if you're going to plan a jail, you've got to plan for alternatives to jail.
It's the law that we didn't follow.
I may have missed the part about the time limit on this prohibition against PPPs, but
Yeah, what it said, it's not, it just says this bill shall expire on. And, I didn't put a date in there, but the intent would be, like as soon as it also calls for a report in 2024. And as soon as the report goes in, then, then things are opened back up to figure out how do we proceed. It's just trying to maintain the status quo of no public-private partnership progress until we take a harder look at the whole thing, and then we can decide. And if the decision at that point is that a public-private partnership is a good idea, so be it. You know, it's just that we need to pause it here and try and figure out what we really want to build.
Yeah, I can support the pause or the moratorium either way. I don't see the great distinction between the two. But
Yeah,
I don't know if
I
we
would-
need to bring the method of funding into the bill. But
Yeah, I use the word pause, Ted, because that was the word that you wanted. And to tell you the truth, when I talked to Sonny Ganadin, who was one of the introducers, that's the word that he wanted to use. So that's okay.
Okay.
But I really would hope you guys will support this bill, because I think this is what the most important thing that's in the legislature right now is the P3, because if they go forward with that and sign a contract before we have a new governor or anything else, then I don't know how you stop it, really. But I do know the legislature does not want that new jail. It's just that, you know, we need to have a vehicle to pause it until we consider, you know, how to make it smaller and not to spend $1 billion on it.
I don't think we need to change what we previously discussed. I think we're okay with moving forward with what we have already talked about in the support of the bill.
But
Ron, Mike, go ahead. But Robert, one last thing.
No, I mean, if you guys endorse it and support it, it's going to help a whole lot in getting community support for it, and that will be the next step.
You were and anyone can answer. We're okay with what we submitted to WHAM and Finn.
Yes, I thought it was wonderful.
And I think Ted and Mike and Ron is there may be some tweaks to that. There may not be some tweaks to that, but that's already written and submitted as a testimony for the bill.
Yeah, and I talked to Sylvia Luke about it this week, and she is 100% exactly on the same path as you are. So, and you know, I also, you know, I mean, she's there, and she's, you know.
What I'm
solid.
thinking, if this particular one, if we resubmit a testimony, we might want to. I wonder if we can do a 3-signature thing so that we 3 have the ability to say something on any of the bills. Multiple signatures on it will allow multiple whoever we send to the committee meeting to speak on it. Because I think we can only write so much, but if they have individual questions, we want to give them the best expertise from the commission to answer. Yeah. I think we're all in agreement at this time. Unless otherwise, let me know now so we can move on.
Just a footnote. I think pause is what in law we would call a weasel word. I like moratorium, but I will yield.
Thank you, Mike. Appreciate it, Mike.
I've been called worse.
Mark,
I didn't call anybody a weasel. I said it's a weasel word.
Yes, Ted.
Mark, I support the bill with the clarification that Bob provided, that the prohibition on the PPPs is for until this thing can be properly planned.
And for OCCC.
Yes.
Okay.
Yeah, I missed that very last line, shall be repealed on.
Yeah, and I figure that they'll fill that in and you know, but if they ask me, I would say as soon as that report that's mentioned comes in, then that's the end of it.
Once we revisit the testimony that we've already submitted to WHAM and Finn that we shared with the public last meeting, we can do those tweaks if necessary, Ted.
Yes. I think the other question is, are we ready to take on a new assignment?
Yeah, and Ted,
Oh, in terms of the committee,
Yes.
as willing as we are to take on new staff.
Okay.
Sorry, Ted.
No, Ma-
And I'll be shocked if
Mark,
we get
I
the committee
think the-
before the director, but
yeah, the committee needs to be formed.
yeah.
My preference is that PSD does it, because this committee should directly advise it, the director should be open to this.
Yeah.
But,
Yeah, Ted,
if he's not going to do it, somebody has to do it.
Ted, if I can jump in, I did it this way because I've talked to Max about this, and he just feels very strongly that he doesn't want to get involved in this. He's going to be accused of playing favorites and blah, blah,
Oh,
blah.
that's baloney.
Yeah, I know, but that's his view. And, frankly, I think you guys would do an outstanding job of putting the right people on it. And I have a lot of confidence in you folks, a lot more than I have in getting the government to do it. I think the oversight people have the insights to form it in the right way. But yeah, that's my thinking.
So Ron and Mike, really what we're talking about right now is whether or not we are capable of handling a committee of this nature. And so I don't think we need to be stuck on that discussion, Robert. That'll be a part of our tweaking of what we've already submitted.
Yeah.
Okay. Thank you. More measures on our women. I wish Martha was here. Ted, I know when I was at almost 20 years ago, early 2000s, that we looked at gender responsive assessments. And did we not implement that in terms of security classifications, et cetera, et cetera? Was that just a classification instrument?
I think gender responsivity really includes classification. It goes beyond it, but classification is an important part of it. Classification is also important in terms of population control and also re-entry. I remember during my last term, I had someone take a look at our classification system, but before my term, when my term expired, it was kind of in limbo. But what the finding was that we were overclassifying a lot of inmates. That's number one. And the second issue is that I don't believe I'm willing to be corrected on this, but I don't think our classification system was normed for women. It was just one general classification system. For example, the big thing that sticks in my mind is if you have an escape, you cannot be placed in a minimum security setting for 7 years. Mark, do you recall if the women had that? Was it part of the women's classification?
Yeah, at the time when I got there, I thought because a lot of their security classifications was based on the male profile.
Yeah. So I think that there needs to be a look at the classification system and make sure that it is responsive to the needs of the women.
And as I look at this, I'm thinking develop and conduct a pre-child female risk and needs assessment. I think this may be in line with everything that they are attempting to do by consolidating all the women on Oahu at the WCCC. Yeah. And creating a more I like to think that they're creating a more gender responsive program for them. And they're starting with these risk assessments. This is being introduced by the committees. So
Yeah, anyway, I think risk assessment and classification is in large part a risk assessment tool. I think risk assessment has a great deal to plays a great part in reentry. The higher you classify people, the longer it takes them to reach the point where they can enter the reentry process. So I think it's a good bill for us to support.
Yeah, I think not only reentry, but assessment of whether or not they need to be incarcerated or whether or not the length of time. Yeah.
Yes.
So population control as well. Mike and Ron, we're agreeing to go ahead and support this particular SB 2721 and HB 2313. You folks have any questions?
No, I'm good.
No, I'm good.
I think it's a good one for Martha.
Okay. Yeah, I would think she's more aligned on the assessment abilities of the department. Okay.
I think Martha worked on our classification systems. This is back in the 90s.
Right. Okay, we'll move on. We're good on that. Recidivism. What is how do you define working group? A task force?
Something like that.
So both of these on the recidivism prevention pilot program, they're asking for a 5-year pilot program. I think we can be supportive, as this is a reentry issue.
Yes, clearly both are reentry issues. The first one, 2532, really is similar to the education type bills we talked about earlier today. It's a reentry preparation type bill.
Okay, all three right here are appropriating funds to for what they're asking for. But I think the pilot program would be a good thing to look at. 2310 is specifically talking about women, but sometimes we need to pilot the program before we can go on a system-wide level. I think HB 2310 and SB 2775 are companion bills. Am I correct on that? Yeah, no. Oh, navigators. What is it? Okay. Ted, I can see us supporting this within our Kuleana. Mike and Ron, any comments?
Nope.
Nope.
Okay.
I'm beginning to get concerned with the work that we're creating for ourselves. Anyway, we can move on, Mark.
Okay, thank you. Reentry programs to prevent recidivism.
Seems like the same general concept.
Right. You know, a lot of this may be the same testimony is really supporting the reentry programs that are being suggested at this particular point in time. It may be one testimony for all these bills. What do you think? Or we may have to go specific, but I think any bill that looks like a positive reentry should be supported.
Yes.
Mark, I agree. I think we should bundle some, and we only have so much energy and credibility. And many of these, it feels like, again, we're going to be micromanaging public safety. But I like the idea of more money with helpers, navigators with lived experience.
And I really want to be able to say in our responsibility from the commission to offer our expertise should the need arise, like as the legislature reviews these reentry bills.
I agree.
So we can provide a systemic view on how these bills affect the system and the flow of the bodies. Yeah. So if we say that's the reentry program to recidivism, then the next one is this the one you were talking about, Kat? 2305?
The two bills, I think.
Yes, 1739 for the House and 2305 for the Senate.
Okay. This is a no permit, and this is in the act that created the commission, right?
Right, Act
We just want to change the
179.
wording, yeah. So we already agreed
It's
to that.
a mistake, but it's a big mistake.
Yeah.
I think it's a no-brainer. We need to support it.
Okay, I'm trying to get you all these reentry bills real quick. 2480 related crisis. Kat, you got any more information on?
Well,
2480?
I don't quite understand
Yeah,
why we would have public safety programs be looked at by human services when they're not, they take care of the juveniles. So I was kind of confused why we're doing that.
I would think the human service element in any kind of collaboration with public safety would always be family. Yeah.
Family.
Because the families may, the affected family may be in the human service system.
Oh,
You know, when you
I didn't think about that.
you know,
Yeah.
you talk about low income and poverty, human service has a handle on many of the families of the incarcerated population.
I wonder if anybody asked them.
No, and that's curious. I mean, me from my perspective can read a lot into that now that I work with Department of Human Service, but
Yeah.
it's really the family element, yeah. And how working with them, I mean, just one angle would be intergenerational incarceration,
Mm.
yeah, because we don't want the children to think that prison is their pathway.
Mhm.
So that's my 2 cents without knowing anything further than seeing
Yeah.
those two things mentioned. But for the purpose of what we're talking about, most of the where were we? The reentry programs as listed by Kat, and if anybody had any more, I think we can be very supportive of. It's just a matter of each particular one will have a statements pertaining to what we can support strongly. I don't see anything that we would not support it. And yeah, gotta be cautious on how I'm saying it. Restorative justice. Okay, wait. So, any more conversations on the reentry portion of this
No.
document? Okay, we're gonna move forward as we support those. Restorative justice. I'm noticing a lot of women measures,
Yes.
which is good. Yeah. Making appropriation to further the practice of Huikai restorative circles of the correctional center. If you just look at
The three restorative justice bills, I think it's a process that can be very effective in the reentry process. Now, my only disappointment with these three bills is that it's limited to the women's facility, but it's better if at the women's facility than none at all. So I think we should support these bills. It's a great process.
I agree, Ted, and I know there has been success with the men as well as the women already. And that was done through community efforts.
Yes.
We really want to put some responsibility on the state to a continuation of these processes. That's what I
Yeah,
feel.
Mark, this has
Go ahead,
been
Mike.
the, Lauren Walker is a genius at this. She's done it for 20 years plus, and I've sat in on them at the women's facility. It's very effective.
And I just want to say Ted was the motivator. We actually, Lauren and I talked to Ted, and he actually started restorative justice at Waiava. So thank you, Ted.
Well, yes, I'm just really gratified to people like Lauren and UCAP for making sure that it stayed alive through all these years. And it really needs money to grow.
Yeah.
So
Yes.
I would support this. I think knowing Lauren, it'll continue regardless, but boy, it really could use some fertilizer there.
Yeah.
I mean, it needs to be transplanted to other places.
Yes.
By the way, Kat mentioned my involvement. This is when I was at Waiava, and it worked wonderfully for men.
Yes.
In fact, one of the men who went through this program later on helped Lauren with the program at the women's.
Yes, it still does.
Okay. Any questions, Ron?
No, I'm good.
Okay. All right, we'll move forward. Just to catch up, everybody. I know we're going over 2 hours right now, but I think we're getting a lot done. So I appreciate your patience and your time. Yeah. Another bill on risk assessments.
We already talked about that.
Yeah, I mean, we can look into the I don't know what's different. Were these the
Yeah.
same bills that he already said earlier?
Might have been.
Okay. We've already had the discussion on the risk assessment. So
Yes.
let's say we're going to go ahead and however each bill is designed, we'll figure out the how we frame our support. But again, as you folks heard, assessment is always crucial for our female offenders who exist in a male-dominated system. Yeah. Solitary confinement. I'll just say something real short, Ted, for the rest of the commissioners. There has been in the past decade, a huge national movement on ending solitary confinement for juveniles. Yeah. And so by the time I got to the facility in 2014, solitary confinement was already ended. So we don't even do that with the juveniles anymore. Yeah. So that's one point. Second point is once success has been achieved in the juvenile system on a national level, they began working at the adult level.
Right.
And so
Hello, Fritz.
as we all know, the Hawaii is normally a
Just
decade
fine,
behind.
yeah. I've been on the computer though.
Oh,
since
I'm sorry, hold on.
7
Kat,
o'clock in the
can you
morning.
mute?
Yeah, I didn't call yet.
Cat, mute.
That's not Cat. Okay, go. So all I'm saying that this is a national trend to move away from solitary. Any other, Ted, go ahead.
No, I just don't know what the motivation is for these bills, but I don't know that within our kuleana, I support the better management, better use of solitary confinement, but I don't see how it fits in our mandate.
Mike or Ted? Hold on,
Well,
Cat.
I know that Senator Nishihara and Representative Ganadin are going to Saguaro the end of February. And when I was at Saguaro, they had solitary, and I don't see much. We ought not to have it unless there's very specific findings and accountability. But that's my take.
So are you taking community testimony? I just want to point out, I feel like
I'm
they're
sorry,
like,
Karen. Go ahead.
sorry, we're not privy, the community to necessarily all of the complaints or grievances that come to the attention of the Oversight Commission. But I know for years there have been concerns about the extended use of solitary confinement, particularly as it relates to people that may be identified as being part of prison gangs, which was a creation of our own doing by sending our people out of state. And so there are best practices, even within the movement, not just nationally, but internationally, to end solitary confinement, given the long-term adverse psychological effects that can impact people long beyond their prison term. So even if you're not ready to take a position today, since you have other meetings, maybe this is something you could take a look at more deeply in terms of the actual content and see if that's something that you could support in terms of best practices. If there are complaints ever coming in raising use of extended solitary confinement or ways of excessive punishment.
I recall we did get letters from Saguaro regarding
Yes.
regarding this, but unfortunately, this is one of the areas where because we haven't been able to have staff, we haven't been able to follow up too effectively, except to ask the department, is this true? If so, please stop it. And that's where having staff becomes really important for us to dig into matters like this. But I think this is something that we should look at in the future, what the practices actually are. The two things, it's a practice, policies and practice while in solitary confinement. And the other part that's really important is the pathways out of solitary confinement back to the general population and back on track to re-enter the community. But for the purposes of today's meeting, I don't see how this fits in. I think it goes to the so-called micromanaging the department category, but only for the purposes of today's discussion.
Ron and Mike, any comments?
Yeah, Mark, for me, as I've been hearing, I don't think we have enough specific information at this time to take a position.
Mark, I taught this at my restorative justice class. It is, I agree, it's a torture. It's unreal. I'd like to know nationally what's going on. I know at Harvard, they view this kind of thing as, if you're not crazy already, you're going to be crazy at the end of being in solitary. So, but I need to know more.
Okay.
Yeah, Yale Law School has done extensive studies on the use of what they call it restrictive housing, various forms of restrictive housing, and in every jurisdiction in the country. So I forget the specific part of Yale, but I can get it if anybody is interested.
There is extensive research about solitary confinement, not just while the person is inside, but people who after release have many problems, mental health problems and suicide. Huge problem. And in Saguaro, this really became important because there are people in solitary who are going to max out this year. That is scary to send somebody from solitary into the community. It's not just, it's scary for the person and for the community. So this is a really important issue about reentry. What we do to people while they're inside is it affects how they act when they're outside. So we need to be really mindful. I'm not saying the commission needs to take a position, but we definitely need to understand that this impacts reentry. Thank you.
I think there's, there's really about, can we submit a commentary on it,
Yeah, I don't think we're ready to take a position on these two bills.
Okay. I'm gonna put that on a pause right now. We're making some progress right now, and that may need a little bit more discussion, but let's move on real quick. Would we be able to support the splitting of DPS?
Sorry, Mark, I missed what you just said.
I'm sorry. I wanted to just take a pause on that, so I, think more about it and then at the same time move forward. Yeah, I'll be right. I want to come back to that. Okay. But I think we can get through this list real quick. Not likely that. Anyway, splitting the department into Department of Correction, Department of Law Enforcement. We talked a little bit about this last meeting. I think we can be supportive of it. Any discussion on that? You remember they were going to create the Department of Corrections and maintain 3 deputy directors, administration, corrections, and rehabilitation. Yeah.
I have some thoughts on that. I read through the bill. It's not every word. It's very lengthy. I think the law enforcement side is not our Kuleana. As regards what the bill does is it renames the current Department of Public Safety to the Department of Corrections and Rehabilitation without the law enforcement components, of course. There's quite a cost attached, more than I believe that was reported in the newspapers. It's upwards of close to $5 million just to get started. As regards the new Department of Corrections and Rehabilitation, there would be 3 deputy directors, 1 for institutions, 1 for rehabilitation, and 1 for administration. My initial take is, so you got 3 deputies instead of 2, you still got the same 5 division administrators and the rest of the staff and organizational structure in place. So what changes? I don't know what the impact of having an additional deputy will have on re-entry and population management, etc.
With a new deputy, it's like you're creating a division as well, right? And there should be employees added, or with
they would have to, right. They would retain the 3 deputies. The new Department of Law Enforcement would have 3 more deputies. But as regards the corrections and rehabilitation side, I don't know how this, I got to be convinced that there'll be an impact on how the correctional system operates, what the difference it will make. Because everything else remains in place.
Is that something that we can place in a testimony?
No, I wish if anybody from public safety is here and they can talk about it, I think that'd be welcome. But at this point, I just don't know enough to support it.
I think, I don't think any of the administrators are present. I think I see Tony. So is Max or Tommy present? Okay. Ron and Mike, you have any comments on this? It's like we can see them separating law enforcement for its own entity, but it's really unclear about the rehabilitation portion of the department.
I think we need to hear from, I need to hear at least from Max or Tommy.
Yeah.
It makes sense on its face, but watch out.
Yeah, I would agree. And how would, keeping in mind that we have certain so-called responsibilities and whether this effectively affects our responsibilities.
Ted, just real quick, right now, would you be able to, you mentioned 5 divisions under corrections. I know there's an institutional division administrator who manages the prisons. There's the
Institutions,
right?
corrections program services, healthcare, correctional industries, and intake service center.
Intake service center.
Yeah, and they're all at the top levels of civil service anyway.
Yeah.
So you impose an additional, what is in effect, political appointee on that structure. I don't know what the impact will be.
Yeah, because the elements of that should be in corrections and elements of them should be in rehab. Rehabilitation.
Well, if they can't do it with the 5 division administrators right now.
Right. I hear what you're saying.
Yeah, because the issues really go to culture and philosophy and practices rather than to organizational structure.
Right. So going back to what I originally stated earlier, is this something we want to say? We want to submit a testimony just to share our concerns?
I'm not inclined to support that notion, Mark.
Okay, so what we have when we look at this one and the previous bill is really not having enough information to really understand whether or not we're going to put our signatures to it. That's what we're looking at right now. Okay, I'm gonna put a pause on that one as well. Let's move forward, because I think we can do this. Oh, these are all going to be attached. This next one, establish the law enforcement to consider administration law enforcement investigation. Okay, just on that line alone, I'm going to say no. Not within our Kuleana. Agree?
Agree.
Agree.
We've had this discussion. These are 2 more measures relating to incarcerated women. I think we can provide the same testimony as what we have already discussed in the above measures.
Agree.
Okay. Ron, Ted?
Yeah,
yes, agree.
This is something that's going to be established in the judiciary to ensure implementation of the recommendations from the final report from the House concurrent resolution. This is an establishment of an entire commission, Ted, the way I read this.
My initial take, I don't know much about these bills, but just from the descriptions, I think the first one, I don't know why it would be placed in the judiciary,
Yeah.
but the whole concept, I think, is very similar to the concept that led to our creation.
Right.
Yes.
And how can we not support?
It's either that or say that in whatever you hope to create in that, give us the position to do it.
Yeah.
Yeah,
Should be
that's
on
yeah,
You know, and then
that's a good point.
I mean, really, I mean, I'm all for it as well, but instead of getting a whole new group of other people, we have it already in place, and all you have to do is add it to the commission, to the current commission and its mandate, so that we have a representation on women's issues within the system.
Or give us a staff person to focus specifically on the women's correctional system.
Exactly.
No, that's what I'm actually
Yeah.
saying. I didn't want to say the S word. You know, the S word is a tender word for us. Yeah.
Show me the money.
You know.
Show me
But
the staff.
Ron and Mike, you hear you understand what we're saying on that?
Yeah, I would agree that this should come within our commission, provided they give us the staff, money, and resources.
Yeah. Okay, so I'm going to get a feel that we can support it with those recommendations. This is women's work furlough.
Okay. I think this bill was, I think the YWCA had this bill introduced, and my recollection is the current law says, subject to appropriation, the Department of Public Safety shall have community-based community-based programs for women, or something to that effect. But what this bill does is it removes the subject to appropriation part, and it simply says the Department of Public Safety shall have a community-based work furlough program. I forget the exact wording, but I think you know, if we support Fernhurst and like programs, I think we should support this.
I like what I see on face value, you know, and when you look at for all incarcerated women, it's also developing these programs on the neighbor islands as well.
Yes.
For our reentry and our jail populations in the other counties. So, Ron and Mike, you have any comments on this? This is a good bill. Within
Yep,
within
I'm okay.
Cubano. Okay.
Yeah, I'm okay with it. I'm just curious is, you know, how are they getting furlough now?
There are work programs that are currently in existence, both from the community, state and private funded, and then there was a work furlough run by the state within WCCC. I think what we hope to accomplish, or what they hope to accomplish with this, is standardizing the system. That's what I would want to believe, and make a
Yeah.
conscious effort to assure that there is a streamline of opportunities for the women as they exit the prison.
Yeah, as a former judge, when I see this kind of stuff, I wonder how come the women was not included if the men already had this.
I think the men have it, except women, because of the numbers, tend to get short shrift.
Yeah.
For example, I'm somewhat familiar with the Big Island situation, and there are some women in the Halenani program, but they tend to get neglected because there are few of them as compared to the number of men. I think the important part of this bill is saying to public safety, you got to make use of the resources in the community. And to be honest with you, I don't think public safety does work furlough as effectively as some of the community programs do. I think Fernhurst does a heck of a job. I think if you look at programs like Maui Best and the Big Island programs, I think they can do a really good job, but they're not utilized enough. And for a lot of times, it's a funding issue.
In the same line that I spoke about indigenous programming, it's really understanding what the system has to offer in terms of the community for work furlough. Yeah, we cannot look at one entity. Yeah, there's a lot of organizations doing great work at the size that they are capable of doing it. So when you have a multiple beds like Fernhurst, and then compared to other programs, Women's in Need, the Salvation Army, Pu'au Foundation, where you talk about smaller amounts, maybe 4 or 5 beds. It becomes a bed issue, but we should be equally engaging in all of them in a system. Yeah, so that our women always have multiple means of programming for work furlough. Yeah, but we need to understand that there's a multiple faith-based community and community working together to create a system. The state needs to take the leadership to manage it. Yeah. So this is something I think we can support. Yeah.
Agree.
Okay. Mike?
Agree.
Work furlough for women with minor children. There's a lot of appropriations ask for all these women programs.
First thing that jumps to my mind is it's appropriation to the judiciary, which may not be appropriate.
I don't know, the judiciary run those programs, huh?
But it seems like it would be for women under the jurisdiction of the Department of Public Safety.
Okay.
But the money goes to the judiciary. I think we should support it. I think the issue of allowing minor children to remain with their mothers, I think there are clearly some positives. I know within an institutional setting, it becomes a little more problematic, especially when institutions are overcrowded. But Mark, you may have some thoughts on that. I think in a community setting,
it's not, in some cases, when you look at a law like this and you look at public safety and the judiciary in terms of allowing a child, whenever you hear that, in my recent experiences, you have to have the input of child welfare. Because most of these families will be coming out of, like I said earlier, Department of Human Service. And often enough, the Child Human Service will say they don't want contact. So and that's not all the cases, but I just wanted to bring that up. Yeah, so when you have a law that's going to say you have to allow the minor children, and one of the departments are saying no for whatever the specific purpose of the journey that they've had with that family. And there's multiple reasons why they would say no. Yeah.
Right, but if it's allowed, I think
It should be done.
there probably would be substantial benefits,
Yeah.
some real positives. What comes to mind is the Women's Way program over in Kaimuki.
Yeah.
And I think it's been going on for a long time, and it's a successful model.
Wasn't there one up in Manoa too? In the valley?
Yeah,
I don't know if that was
Salvation Army. Yeah.
It is
I
Salvation
think
Army,
I
okay.
think they consolidated
Yeah.
in Kaimuki, but I'm not sure.
What's important to also state is that, you know, who in the community has the ability to create this type of programming and the structures.
Yeah, I think to the extent that we can have community agencies do a program like this, I think it'll work, and it should be supported.
Okay. So we're Mike and Ron, I think we're going to go ahead and believe this is our Kuleana and support this particular bill on work fertile and children. Okay.
I agree.
Right.
This goes back to what 1776, Ted, you know, there has been work fertile established, but maybe they just want it in the law.
We've already covered that. It's
Yeah,
on there
okay.
twice. No wonder it's 16 pages.
Yeah, okay. We talked about this. We're gonna support work fertile judiciary. This one is just is in general. Oh, hold on, they're talking about women too.
Which number are you on?
2772. It's under work fertile judiciary, HB 2473. Oh, I don't think we want to support 2473. Transfers responsibility for vocational, educational, culture, and other programming and services from offenders from PSD to the judiciary.
Mark,
Yes.
I know we'll hear from our Chief Justice, who's excellent. We in the judiciary are the third branch with the last say. We're not an agency. So I would be against this unless Ron or somebody gives me a good reason.
Ted, you see where we are?
Yeah.
First off, is it our Kuleana to say anything on these two subjects? As they're considering it to the judiciary. And I hear what Mike already said, so I'm just hearing from Ron and Ted. That's the key, Mike, on that first line. Appropriate funds to the judiciary to create and expand existing community-based furlough programs. Does the judiciary run furlough programs?
I hope, but I don't know.
I hope not. Yeah.
Yeah, actually, Mark, yeah, we don't run, the judiciary doesn't run furlough programs. You know, here I'm looking at the bill, they're talking about residential drug treatment,
This is Bob
therapeutic
Merce calling.
living,
I
mental
received a call
health.
from your department.
Bob,
I've been
can you
referred
mute?
to you guys by Dr. Kozak for an hearing test.
And actually, I think on Maui, when they started the drug court, and they had, I don't know, an MOA with the parole folks that because while they were out on parole, they needed drug treatment, and I think the Maui drug court took some, parolees into the drug court program. And actually, when I was running the drug court program, I looked into that because, and Ted, you can correct me because I keep hearing that cash box, it's filled, and because it's filled, they can't get their drug treatment, and because they can't get their drug treatment, they can't come out on parole. So I looked at whether we could have done something similar to Maui, where you can, release them out on parole, and they'll get their drug treatment in the judiciary drug court, residential program, well, not a residential program, but a drug court program. And of course, we never went forward with that. So, but as far as, the furlough, if you're talking about furloughs, unless the public safety say, well, you can release on parole as long as you're in the state court drug treatment program, maybe this could be funding those situations, but I don't know.
Yeah, I pulled the bill up, and what the bill says, it appropriates funds for 3 categories. I'm looking at 2771. I'm sorry, 2772. There are 3 categories. One is new and existing community-based furlough programs, and that's not in the judiciary.
No.
The second is residential drug treatment, and I think the judiciary does refer to residential drug treatment. And the third is a comprehensive database regarding justice-involved women and their families to better inform decisions. And I think those are judiciary responsibilities. Number 1 is not, but number 2 and 3 definitely are. And I think those 2, if we can get improve the programming there, it goes to reducing the number of intakes into the prison system. So I don't know how effective or at what level they're funded, Ron or Mike, in terms of residential drug treatment programs. But if you ask the judiciary, I'm sure they'll say they can use more.
Yeah, and yeah, since you brought that up, yes, I think the judiciary would have more of an interest in this.
Yeah. On number 3, the comprehensive database, that's something that I would like to hear from the research center at the judiciary that was created concurrent with us.
Harbinson.
Yes.
Well, I've been underwhelmed with what they've given.
So there's a lot of bullet points on these bills that may or may not fall within the preview of our Kuleana. We can see already we have a lot of work cut out for ourselves and what we said we were going to support above us. Because this is labeled judiciary, how much effort do we want to put into this?
I think we should either walk away or defer that. It makes me uncomfortable. I don't mind being uncomfortable, but this one I don't like.
Yeah.
Okay.
I think a lot of the other
with
stuff, a lot of the other bills that we're supporting, especially involving women, are already specific to public safety. Yeah, and then here we're going to create something else in the judiciary. So we want to focus on one organization having the responsibility for that process.
Right.
Ron and Mike and Ted, let's defer this. I'm cautious right now because we got 15 minutes. I think my Zoom thing is 3 hours before
Okay.
it cuts off. So I just want to, I don't feel too strongly about this either. Like Mike said, I feel kind of uncomfortable, but without the whole, a real comprehensive study of this bill and how it affects the other ones that we just talked about, decision-making will be, cloudy. So I'm going to move on right now and see what we can do with these other bills in the time period that we have. This is the expungement that we talked about last meeting. 1735 and the companion bill 2861. Mike or Ron, you want to do a quick discussion on that?
Yeah, I would support this bill because right now there's a lot of problems as far as people having criminal records whose records should have been expunged, and right now it's not an automatic process. The lawyer has to go in and file a motion with the court, and a lot of times, even with the deferral pleas, where records should be expunged because it's not a conviction, it's a deferral of the plea. There's a lot of people out there still have this criminal record, and it affects their job status and things like that. So I would support this as an automatic, expungement.
I agree, Ron, if I could. When I was on the parole board for 8 years, this was part of the calendar to come up every month or two. It has to go through the AJ. It takes literally months or years to get to it. Then it was all a paper review. It wasn't real. It was unfair, delayed, and I think wrong-headed. And I was, frankly, I don't want to be appalled, but I was extremely disappointed. I expected more. So that's where we might need staff, but I support this very much.
I believe it's Kuliana on the reentry. Ted, you wanted to say something?
No, I support.
Yeah, so we're going to move forward. Support on this. I know, as I can recall, Martha was working on this.
Yes.
And, so we'll tell her that we approve the support. Mike, can you lead some of this? Or are you familiar with that these are up?
Well, I'm still treading water here trying to read this. Somebody can brief me on it. I don't want to respond until I read it better.
Kat, or do you know anything about this, Carrie Ann?
Yes. So if we can just go back one quick step to the clean slate bill, because Martha has been involved in conversations. I just want to add, it's not on this list that Kat has, but it's on the list I sent to you.
Okay.
For what we call clean slate, it's those two bills that you have on the screen are more piecemeal. It doesn't allow for more comprehensive expungement, automatic expungement. SB 3159 and HB 2343, which I put in the chat function. That's the bill that we've been working on, that's clean slate, comprehensive across the board. So we want to encourage you to support that, take that position. On the other two measures that Judge Town just made reference to, so SB 2514, probation, SB 2515, parole. This is the bill that I shared with you the last time, where the intent outcome is to reduce the number of admissions to jail and prison for persons who have technical violations for both probation supervision and parole supervision. It also would mandate that it would remove individuals from prohibiting association with other individuals unless there is a crime that's specifically targeting a certain person. So you could still be mandated not to associate with that person, but just in general. It also would create good time or good earned credits for individuals on probation or parole. The statute as drafted does not list a number of days. But for example, in New York, they passed legislation called less is more. So if an individual had 30 days on parole or probation, no violations, that they would have, in the case of New York, 30 days taken off time. So it's a positive base, cognitive base incentive for people to comply with conditions of community supervision. and decrease the length of time under probation and parole supervision. Because again, the belief is that the community, if somebody is not convicted of new charges, particularly felonies, then that should be addressed in other ways and not by incarcerating people in our already overcrowded jails and prisons. And this again is supported by research based, evidence-based practices. And this would decrease our population. And 20 to 25% of all jail prison admissions are based upon revocations. This impacts males as well as women and men, including those here in Hawaii and those who are out of state. If you look at the population count on any given week, you'll see the number of probation quote violators, parole violators, and it's very stark, and this is consistent for years. And this is the way we can, again, decarcerate, reduce the population. And I'll pause there if there's other questions or concerns about those measures.
Ted, questions? Anybody questions? Can we support the concept of what these this particular measures introduce?
25% of the current population are parole and probation violators, according to the January 17th population report.
Just giving the directors time, the commissioners time to review the bill.
Mark, my screen share went off. I can't see it.
Can you guys see it now?
No.
No,
We may have to do a supplemental, God forbid, hearing because we're running out of time and my blood sugar is starting to head south slowly. I'm eating grapes.
Okay, hold on, Mike. Sorry.
Yeah,
Not
I would
drinking wine, I'm eating grapes.
on this bill, I really would like to hear from Mike as regards to parole process and Mike and Ron as regards to probation process. And what I see this doing is automating the reduction of probation or parole time by giving good time. You meet all your conditions for a certain period of time, your probation is POW, your parole is POW. And I know there are mechanisms in place right now to reduce your length of probation or parole. But these require more formal hearings. And I'd like to know what the impact would be on a good time. We already grant the reductions. I just want to know what the impact of a good time system would be.
Yeah,
Can you hear me, Ted?
Yes.
You froze.
Hello?
I can hear you. I understand what you're saying, Ted.
Okay.
Ted, can you hear me?
Yes, I can.
so if I may, this is Ron. Regarding probation, a person is placed on, say, probation for a term 5 years, and with conditions, special conditions, and general conditions. So when the probationer allegedly violates any of these conditions, the prosecutor brings a motion to revoke probation or modify terms and conditions of probation. The judge hears it. The judge can revoke the probation, re-sentence the defendant to a new probation period, or send the defendant to prison. And there's been times where a person who's on probation, which I always said, before I cut him loose, this person's in probation. If the person went prison, he would be out of the jurisdiction of the courts. They have people on probation for like 10, 15 years, because every time this 5-year probation is revoked, new probation period without any credit. Of course, court has already the discretion to shorten terms and conditions of probation. The court may also early terminate the probation period for whatever good behavior or whatever the attorney brings up. So basically, there is no formal mechanism to give credit, good time credit, but the judge has the discretion, which is rarely used. Again, it has to be brought up by the defense attorney for early termination for whatever good behavior or compliance with the terms and conditions of probation. And so now this bill in giving good time, I guess court would have to give them good time. And I don't know, I haven't looked in specifically where when a probation period is revoked and the person comes up for resentencing and the judge said, well, I'm going to place you on 1, 2, 5 years probation, and this would give you credit for the probation period, as far as for good time, almost like sentencing a person to jail, and the person was already in jail on pretrial. The court said, well, you got credit for time served or whatever. So I'm not sure how this would affect, new terms and conditions of probation that would mandate the court to give time.
Ron, the other part of the bill, which I neglected to mention, is that it says that you cannot send a probationer to jail purely on a technical violation. If the violation is a technical violation, and if it's something to do with substance abuse, you have to send to a substance abuse program instead of jail.
So yeah, and the standard for revocation of probation is the court must find that the defendant violated a substantial term and condition of probation, which I look at, it's related to basically rehabilitation for the crime charged. And the judge does not.
I can't hear.
Yeah, the judge does not have to, the judge has a lot of discretion in probation resentencing.
Now, if the process requires, does the process require the probation officer to file, and is in between the time of the filing for a revocation and the hearing itself? Excuse me.
Ted, I'm gonna stop the conversation right now because we're on a hard stop pretty soon. I'm pretty sure Zoom's gonna cut me off at 3 hours. So real quick, we had a lot of work done today, and I'm looking at a possibility of regathering on February 11th at 9 o'clock, which is a Friday, to see where we are. All the information of all the bills that we're going to support is going to take a strategy on how we get it done and get it to the committees that we need to get it to. And if anything, hopefully, let's just focus on what we said yes now. Put these others on the side until we can get more information considering isolation, splitting of the department, parole and probation, so that we can make more informed.
Can anybody hear me?
On the next one. So that's
I hear
kind of
you,
where
Mike.
I'm at right now. Are you okay with that, Ron?
I am.
Ted?
Yeah, except that February 11th, the bill would have moved on by then.
And then I'm just throwing that out now as the time is shorting by. If I can with some of the help of the community, look at the schedule of when bills are appearing, I can try to schedule something easier and within the sunshine law.
Yeah, let me ask Lisa this. Lisa, is it possible for us to recess, subject to recall subject to reconvening at the call of the chair, specifically to give Ron and Mike time to review these bills and report back so we can take a position?
You can do that, but you have to announce a time. You have to set a time. You cannot just say whenever the chair wants to. You have to
Okay.
give, you have to
That's
set
why
out an
I just
agenda.
wanted
at
to
least
settle on the February 11th, and should that change, we can post an announcement, as long as we get that 1 week ahead of time, right, Lisa?
Yes.
Yeah.
Yes.
Do we need that though? Because we're already in meeting, always saying we're recessing until whatever date without, there's no sunshine law issue.
Yes, but you still have to announce the date, the
Yeah,
next date
yeah.
where you're gonna
But I'm saying
announce.
there's no need for the 6 days, we can just set it now for tomorrow or next week without looking at the 6 days because we're in recess.
I'm not sure about that, but I think you still need to give notice and adequate notice to everyone who wants to attend.
Okay.
Yeah, but we're just continuing the agenda. Right? We're not
well, you
adding a new
can.
agenda.
You can. I just hesitate to say, I'm not sure how short you can roll it over.
How much notice do we have to give of the date, Lisa?
I know with the agendas, you have to give at least a week ahead.
Okay, I expected Zoom to have stopped and it hasn't. So what else we need to discuss on the parole and the probation? It's the same wording. Are we comfortable to say that we're gonna submit support or not?
So real quick answer to Ted's question, I see. Yeah, if the motion to revoke is filed, it tolls the probation period. So
Right,
basically,
but-
until the hearing is heard, the person's probation period is tolled and then starts again. So they don't get credit during that period.
The other question I had on that, Judge, was after the motion is filed, is a warrant issued for the arrest of the probationer, and the probationer can be incarcerated during this period until the hearing is held?
Yes, depends.
Because
The
as I
probation
read
officer,
this,
yeah, it can.
as I read this bill would not allow that, would not
Yeah.
allow the incarceration during this period.
Okay, that would help.
Do you think it's a good thing?
Well, I guess I didn't read the bill, but it has to have certain type of cases, right? If
Right.
the seriousness of the charge and the offense, I mean, the violation. But, without knowing more, it's just, I would say it helps because, the person is out on probation anyway. And if the person has committed another crime, allegedly, a warrant on that new offense can issue without, and the probation, usually sometimes anyway, the court just say, I continue this probation revocation hearing until the disposition of the new charge.
And if it's a technical violation, is a warrant issued and the probationer incarcerated?
Yeah, see, that's up to the judge now. Yes,
Yeah.
yes, it depends. Yeah, you're right. Yeah. So there's nothing to tell the judge you can't do that.
So this bill would tell the judge you can't do that unless certain conditions attached to the case.
Yeah.
So what's the feel? How do we feel on the parole and the probation? It's almost the exact wording, so. This is our last one, and it's like the same, I feel like we're in the same position as the splitting of the department and the isolation question.
But Ted, if you have any questions,
I support the idea, the concept. I'm not just familiar enough with exactly how the process works. Who gets detained, pending the hearing and who doesn't get detained. To take a firm position on that part. But I support the idea of facilitating the reduction of probation and parole, assuming compliance with the terms and conditions.
I agree with you, Ted and Ron. Parole is a mess, and I've talked to Fred about it.
We want to be able to say how we support it and then put our concerns in there, Ted, in the testimony. That's what I mean.
Yeah.
I hear some TV. If somebody who's left on the meeting can mute yourself, please. Thank you.
I would have Ron and Mike review these bills, the respective bills, and draft testimony as they see fit, given the general support of the concept.
Okay,
That's fine.
I'm agreeable. Okay.
Are we done, Chair Mark?
You can have your wine now, Mike.
I don't want wine. I want lunch and maybe a nap.
Okay, real quick, because I put a pause on it. In terms of the isolation, my comments on the isolation bill was really, some of the community meant what they talked about. I would lean toward, it's just like what we just talked about parole. It's just more information, yeah, on how we can be responsive to that particular measure. I know, Ted, you said you don't think we should be supporting that.
No, I said I don't think we should take a position.
Okay, so in taking the position, can we provide testimony, or just we're not gonna take a position?
Frankly, I don't think we know enough about what's going on.
Yeah.
I think it's something that needs to be done, but we're not in a position to know enough at this time.
Okay. And are you going to stay with that the same as far as splitting the department? Not enough information?
Yes.
Okay. Okay. Ted and at this particular point, is Mike leave?
No, I'm here.
Oh, Mike and Ron, now we're just gonna put that on a pause until we can get more information. I want to still stay with that date because I publicly stated it, December 11th. And so that we have a date should stuff happen in Ledge that we want to come back and talk. And then let's see what happens, whether or not we can actually make that happen. Okay.
February 11, you mean?
Yes,
At 9 o'clock.
at 9 o'clock.
Okay,
Because I believe our meeting is the following week.
yes, the 17th.
Yeah, so these meetings are specifically to discuss legislative concerns, if we have any. I want to be able to just have a meeting set if we have it, if concerns arise through this process.
Mark, I'm signing off. You guys are awesome. You have much more patience for this than I do. I'm just amazed that you worked your way through them with great sincerity and real concern, and extremely impressive. Thank you, guys. It's awesome.
I just doubled your salary, Bob, and you doubled mine.
Hey, I mean, this is really this is hard work, and you did a spectacular job of thinking through all of these bills. You had more patience. I would have just said, So congratulations, great job.
We had the conversations. Now we got to put hand to pen, pen to paper.
Yeah.
So,
thank you. Thank you all.
Thank you.
Thank you.
Are we
Thank you,
done?
everybody. I'll just say my aloha to everybody right now. Stay safe, and thank you for all the help in helping us monitor the bills. I appreciate
Aloha.
all of you.
Thank you.
Aloha.
Aloha, everyone.